What Fredrickson is doing in C2 to 3 is reframing a regulatory enforcement issue as a private housing tort. Stripped down, his claim requires these elements to hold up. 1. He had a lawful tenancy. 2. There was no legal basis for removal. 3. Gray acted outside lawful authority. 4. Gray's communications directly caused an unlawful termination of tenancy. 5. Required procedural protections were bypassed. Based on what you've described, each of those points is contestable. Nurse Harbor 1. Lawful housing at Property 1. If the property was zoned commercial and he was renting an office is not a lawful dwelling unit. Commercial zoning does not confer residential occupancy rights. Sleeping there does not convert it into protected housing. No certificate of occupancy for residential use equals no lawful residential tenancy. If that's accurate, the statement, plaintiff had violated no lease terms and no lawful basis for removal existed, becomes legally irrelevant. Zoning compliance is independent of lease compliance. You can fully comply with a lease and still violate county code. If the use itself was unlawful, procedural eviction protections tied to lawful residential tenancy may not even apply in the way he is framing them. Number 2, code enforcement versus interference. If Gray was acting in his official capacity, responding to a complaint, inspecting the property, identifying code violations, notifying the responsible party, owner or leaseholder, warning of potential fines or penalties. That is textbook enforcement activity. It is not asserting complaints designed to have plaintiff removed. It is notifying responsible parties of violations. Intent matters legally. If the action was regulatory enforcement, not personal advocacy for removal, his narrative weakens significantly. Hammers 3. Who was the responsible party? You state, Gilmore was not the owner. Gilmore was a tenant leaseholder. Enforcement actions were directed to the responsible property interest holder. No eviction was filed by the county. Eviction was never applied for. That's critical. Code enforcement does not evict occupants. Courts do. If no eviction was filed and no court process occurred, then the county did not terminate tenancy. The landlord's decision, if any, was independent. The procedural protections he references apply to judicial eviction, not to a landlord deciding to discontinue an unlawful occupancy. 4. His prior federal case admission. You mentioned that in Fredrickson v. Larimer County et al., 122 CV-00262, he stated he chose to leave properties 1 and 2 voluntarily without eviction. That is potentially damaging to his current claim. If he previously represented to a federal court that he left voluntarily, no eviction was necessary, then asserting here that he was effectively forced out without procedural protections raises consistency and credibility issues. Prior inconsistent statements are not minor. They go to the heart of causation and damages. 5. Procedural protections argument. He argues, open quote, plaintiff was not served with written notice, not afforded procedural protections required before terminating a lawful tenancy. Close quote. That assumes he had a lawful residential tenancy, a governmental actor terminated it, due process protections were triggered. But if the occupancy was unlawful under zoning, enforcement was directed at property compliance, no eviction action was filed, he left voluntarily, the landlord made the decision. Then the constitutional due process framing collapses. Due process attaches to governmental deprivation of a protected property interest. The threshold question is whether he had one. Living in a commercial office is not automatically a protected residential property interest. Number 6, the strategic reframing. What he appears to be doing is converting code enforcement into personal harassment, converting zoning violations into protected tenancy, converting landlord decisions into state action, converting voluntary departure into forced removal. That's a narrative strategy, not necessarily a legal one. Bottom line, if the facts are as you've laid them out, Property 1, commercial use, no lawful residential tenancy, enforcement directed to property interest holders, no eviction filed by county, prior admission of voluntary departure, code violations independently documented, RV violations present, then the core dispute becomes whether Gray acted within statutory enforcement authority. If he did, the word interference is rhetorical, not legal. If you're building a response, the clean structure would be 1. Zoning classification and lack of lawful residential use. 2. Statutory authority of code enforcement. 3. Enforcement directed to property holders, not tenant removal. 4. Absence of eviction proceedings. 5. Prior inconsistent admissions. 6. Lack of governmental deprivation of protected property interest. That's where the real legal pressure points are.